Good morning, Judge Keightley.
Good morning, Chief Justice.
How are you this morning?
I think the accurate description is as well as can be expected. I trust you are well.
I think that's good enough. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview this morning. We will ask you questions which are aimed at satisfying us to what extent you meet the selection criteria that has been adopted by this body for judges for appointment to various courts. We might ask you difficult questions, but nobody will be meaning to treat you unfairly or in any way wanting to block you from appointment to the SCA.
Thank you.
Everybody will just be trying to satisfy themselves that you meet the criteria.
I understand.
Yes. We have got our bundles which have got a lot of information here that you have supplied. Therefore, we are not going to seek to cover the information that we have. Everybody is presumed to have read the bundle. We will seek to simply highlight or focus on certain areas that we will be wanting to test you on.
Thank you.
And I will ask you some questions, and thereafter I will ask the president of the SCA to ask you questions, and thereafter the minister and other commissioners who might wish to put questions to you. Okay.
Good, thank you.
Thank you very much. I see that in terms of your academic qualifications, you obtained a BA from the University of KwaZulu-Natal. It was known as University of Natal then, 1982. You got LLB summa cum laude from the same university, and you got LLM first class from Cambridge University in the UK in 1988.
Correct.
And you served articles, and you got admitted as an attorney, is that right?
Yes.
And you practiced as an attorney for 1 year or 2 years, is that right?
I think it was probably around a year.
Yeah, around a year, yes. Over the period between then and your appointment as a judge, you spent some time in the academia. You were a lecturer, a senior lecturer, and an associate professor.
That's correct.
And you also spent some time in the asset forfeiture unit of the NPA, is that right?
Yes.
How many years did you spend there?
I think I spent, it was until 2006.
Yes.
It was 7 or 8 years, if memory serves me correctly.
Yes.
I was there from more or less the beginning of when the asset forfeiture unit started.
Yes.
Until I felt I wanted to move more into general law.
Yeah.
I felt I was getting a little bit too specialized.
Yes.
And that's when I went to the bar.
Yes. And at the bar, you didn't spend many years successively practicing. You were always also doing other things, including teaching a little bit, is that right?
While I was at the bar, I was appointed as the director of the Center for Applied Legal Studies at the University of the Witwatersrand, which is a very old, well-established human rights institute.
Yes.
And for about 3.5 years, I ran my bar practice concurrently with heading up the Center for Applied Legal Studies.
Yes.
And then went back full-time to the bar.
Yes. While you were practicing at the bar, did you do any substantial number of cases that got reported in the law reports?
I haven't looked at that for a while since my interview for being appointed to the High Court.
Yes.
But I do remember including some that were.
Yes.
I remember appearing before the Constitutional Court
Yes.
in a matter where I represented the Centre for Child Law.
Yeah.
And that matter was reported. I can't remember the name, I'm sorry.
No.
But that matter was reported. And then
Yes.
there were a number of others that were reported where I was junior counsel.
Yes.
In the Constitutional Court matter, I argued as counsel.
Yes, no, that's all right. And as a lecturer and associate professor, you also published some articles.
Yes.
And you wrote chapters in a
That's
number
correct.
of books, about what, 11 books?
No, I think that those were the articles. Oh,
Yeah.
if you count I used to do the chapters on trusts and succession
Yes.
for the annual survey of South African law.
Yes.
And so, yes, you are quite correct. I did that for a number of years.
Yes, I see that actually you wrote and edited 2 scholarly legal books.
Yes.
And 16 book chapters.
Yes.
And 11 articles in
Yes.
peer-reviewed academic journals.
Yes, absolutely. That is correct. Most of my articles were on human rights topics.
Yes.
And then, of course, more sort of the annual survey chapters were more straight down the line law,
Yes.
succession and trusts, although
Yes.
the law of succession obviously has its constitutional aspects as well,
Yes.
particularly in terms of gender equality and so on.
Yes. Of course, in the questionnaire, you go on to indicate some of your articles which have been cited
Yes.
in decisions of various courts.
That's correct.
And I think you mentioned the Constitutional Court in one or so cases as well.
Yes, that's correct. I
Yes.
think that was the one on public international law is one of my areas of law that I taught and wrote in.
Yes.
And I think that was one of the articles that was referred to. The
Yes.
other one that has been referred to rather often is on the Extension of Security of Tenure Act.
Yes.
So that was on land restitution.
Yes. I see that you say that I think you have covered almost all branches of law as a judge of the High Court, if I understood
I think
the question correctly.
the only field of law that I can't recall writing on is shipping law.
Yes.
And there's an obvious reason if you're in the Gauteng High Court. There are not many ships that dock within our jurisdiction. So, but I think I've covered the field, so to speak.
Well, I don't know if you are able to, but you should be able to at least mention as many branches of law as you can remember in which you have given judgments.
Certainly. Administrative law, I've dealt with a number of administrative law judgments. Constitutional law, I've developed the constitutional, I've developed the common law in YG versus the state. That was the judgment dealing with the reasonable chastisement defense in our law of delict. And there have been other cases where I have dealt with constitutional issues. Contract, commercial law, I've written a number of tax judgments, one of which was upheld by a full court and then subsequently also upheld in the Supreme Court of Appeal. That was Commissioner of the South African Revenue Service and BMW. I have written in patent, trademarks, unlawful competition. I have written equality court matters involving equality court, matrimonial matters, children's matters. What have I left out?
Customary law?
Sorry, Chief Justice?
Customary law?
Customary law I have.
Yes.
Yes, I have. Not reported judgments. And I was hoping to get a reported judgment because one of the judgments that I was assigned to scribe in my last term at the SCA was the King Partlaw judgment. And then, unfortunately, because of information we received at the hearing of the matter, it turned out to be moot because the president had already appointed the king. So it ended up being a judgment on mootness rather than than on customary law. But I also taught customary law at university.
Yes.
So I am familiar with it. And in Johannesburg, it's not unusual for us to get customary law cases. And so I'm very familiar with the area.
Yes. And the labor law?
Labor law, no.
Okay.
I did do labor law when I was an articled clerk. In fact, I brought labor law matters into our firm and did a number of unfair dismissals. But when you get into practice, you are, as an advocate, you're largely determined by the briefs you get. And for whatever reason, labor law didn't come my way.
Yeah.
The closest we get to it in the High Court is really when you're dealing with those barrier cases, when I say border cases, borderline cases where a person may bring a case to you that deals with employment, but they bring it on a contractual or an administrative basis rather than straight labor law.
So constitutional law, administrative
criminal law,
contract
procedural
law, criminal law,
procedural law,
trademark law,
patents,
patent law, yeah,
tax
you have done
law,
it, tax law, international
company law, business rescue.
Yes.
I've said equality court. I was
Yeah.
trying to look at it alphabetically, but that doesn't always
Yeah.
doesn't always help one.
Yes. So you have had quite
I've had very broad experience. I've been very lucky in the division I am in.
Yes.
We do get a range of matters that come to us.
Yes. Would you like to share with the commissioners your understanding of the doctrine of separation of powers? Separation of powers.
Very simply, I believe, as an ex-teacher, I believe in trying to explain things simply. So I'll endeavour to do that. Essentially, under our constitutional system, there are three branches of the state. The executive that really has the task of giving effect to laws, putting them into action and application. We have the legislature, which makes statutory laws. And then, of course, we have the judiciary. And the doctrine of separation of powers recognizes that each of those branches of government, of the state, not government, of the state, operate within their defined spheres, and that they should not trench on the sphere of any other unless they are lawfully entitled to do so under the Constitution. An obvious example of that would be the judiciary can and must rule on the constitutionality of executive action and obviously of legislation.
And rule of law?
It can mean many, it's a very broad concept, but from a constitutional point of view, broadly it would be rule by law. It's a founding value in our constitution is the rule of law, but really my understanding of it from a constitutional point of view, it's very closely linked to separation of powers, and it would mean that each branch of the state cannot exceed what they are lawfully entitled to do. And so it really ensures that government as well as other arms of the state and organs of state operate within their constitutionally and legal defined boundaries. And that's to ensure that there's certainty, it's to ensure that there's constitutional security in the state, and the different branches and organs of state can be held to account, generally through the courts, if they act beyond their permit, because they would then be, they would have undermined the principle of legality, which of course forms, I think, the core of the rule of law. from a constitutional point of view.
Thank you very much. President of the SCA.
Thank you, Chief Justice. Good morning, Justice Keightley.
Good morning, President Molomela.
Just following up on a few questions that
Yes.
were posed to you by the Chief Justice.
Yes,
It seems to me that you have had exposure to a broad spectrum of branches of law.
correct.
Yes. I tried to establish from your CV, but I might have missed it. I'm curious to find out on what subjects or courses you lectured on at
Yes.
VIS and UCT.
Yes. I started my lecturing career, in fact, being responsible for devising a course falling under the academic development program. So it was a bridging course for law students who had potential, but who came from disadvantaged backgrounds. At the same time, I lectured in the introductory courses, Introduction to the Study of Law. I then also lectured in family law. I lectured in succession. I lectured in African customary law. I lectured in public international law. When I went to the University of the Witwatersrand, I continued to lecture in public international law. I lectured in the law of property as well. And then generally, I think that probably covers it.
I see. And so you mentioned that at the High Court you were never exposed to shipping law, which is
Yes.
not surprising.
Yes.
But have you ever had to be in a panel in a matter that deals with shipping law, maritime law at the SCA?
I haven't as yet. I look forward to that challenge.
I see. All right. So you started acting at the Supreme Court of Appeal last year,
That's correct.
and that was your very first acting stint.
Yes.
How did you find it?
I found it challenging, but in the most positive sense. I enjoy a challenge. I know that I'm up for a challenge. And I really, it pressed those buttons for me. I found it to be stimulating. I enjoyed the teamwork approach that one has to adopt if you're sitting in an appellate court where you are not the only judge. I learned a lot from the interchange of ideas and particularly experiences which one gets from a transformed court like the SCA.
Yes.
I enjoyed the discipline. I enjoyed the fact that you have to be prepared for your hearings, and then you must produce your judgments with quite a quick turnaround. I found that I had enough time to do that. I am quite an efficient worker, and I enjoyed working to that timetable. So all in all, and the collegiality was unbelievably positive. It really is. It is a court that is driven by the sense of a team, which I found to be extremely, extremely heartening. And could I just end off by saying, I realized it really is a privilege to be invited to act there. And when you get there as a high court judge, particularly if you come from a very busy division, you realize how much of a privilege it is, because it's a small court, but yet it's dealing with, for the most part, it is I know it's not the apex court, but for most litigants, that will be the court of last call. And so I had an overwhelmingly positive experience at the SCA.
Thank you. I'm glad to hear that you were not overwhelmed, because I was very conscious of the fact that you were acting there for the first time, and unfortunately you came there during lean times.
Yes.
You know, when judges have to rely on only 3 law researchers And that means that, you have to be able to be self-reliant and to
Yes.
work independently. Would
No,
you say you managed that very well?
Oh, without a shadow, I am self-reliant. I went to boarding school at the age of 6. And so I learned to be self-reliant from an early age. But I'm an efficient worker, and I'm one of those judges who can hit the ground running. And I remember President Molomela, I don't know if you remember this, but I was supposed to act for the 4th term of last year and the 1st term of this year. And you called me up early and you said, "Are you able to come a term early?" And that was at the beginning of July. And the term started in mid-August. I got my records from the middle of July onwards. But I'm not easily overwhelmed. And I felt I didn't feel overwhelmed, and I certainly hope I didn't give the impression that I was overwhelmed. I felt I was able to cope adequately.
Yes. And you touched on collegiality. You realize the importance thereof since, we all work as a panel.
Absolutely. Yes, I really do, and I enjoyed working in a collegial way.
Yes. And you'd also be mindful of the fact that judgment writing is a very collaborative exercise at our court, so you depend on the inputs that you get from other colleagues as well. So
Yes.
during your stint, were you giving a lot of inputs to other colleagues? Were you also receiving inputs, and were you amenable to incorporating those inputs?
I received, and I believe it's one's duty to give comments and make suggestions. It's courtesy. You've expected your panel members to be doing it for your judgments, and so I would make a point always of giving what I felt would be helpful suggestions. I always accept suggestions unless I don't agree with them, because I understand the teamwork ethic. If people are going to agree, they must be comfortable in agreeing to your judgment.
Yes.
So my approach is to accept, unless if I don't agree, and then I would normally talk to the judge who's making the suggestion and discuss it if needs be. I never had any of my judgments substantially rewritten or substantially commented on.
Yes.
They mostly were received favorably, and certainly with very useful input to make them better, which is to be welcomed, and I certainly welcomed it.
Yes. Have all your judgments been handed down promptly or produced promptly at least?
I have a record in the High Court. I think all of my judgments, bar 1 or 2, were within 3 months. At the SCA, I had hoped that they would all be handed down now. We're conferencing a judgment I picked up in the very last week of me acting there. We're conferencing that one on Wednesday. And then there's one outstanding which has a very long history, and I anticipate we'll be conferencing that one next week.
Yes. And you've never been the source of a delay in another colleague's judgment in terms of giving your own input on that judgment, or in terms of taking long to write your separate judgment if you have chosen to write separately?
Not that I'm aware of. I've tried to give my comments promptly, because that is the mode of the court. That's how it operates.
Yes.
I've written one dissent together with Judge Faiza Keightley Setlwane, and that was delivered promptly. The dissent was delivered promptly. The judgment also had a long history, but that wasn't because of our dissent. It took a long time to get there.
Yes.
So no, I can say in all honesty, I've never been responsible for that.
Yes. So I see you've been a permanent judge for 8 years.
Yes, I'm in my 9.
Yes. But prior to your appointment to the bench, you were in the legal profession.
Yes.
For approximately 27 years.
I'm in my 39th year of legal practice.
Yes, okay, I've got it wrong here. I've got it as 35. So it's actually 39.
Yes.
Yes. So what, in your view, is your special attribute that you will bring to the table at the SCA? What will be your most important contribution? I'm asking this question because, as you are aware, we have lost a lot of colleagues due to attrition. As a result, we have lost a lot of experience and
Yes.
expertise. So my question really is, what will you bring to the table in terms of experience, expertise, your skill set in general?
I think I'm quite uniquely placed in that regard. I have many years of legal practice in many diverse fields, and they have all contributed to the judge I am today. And I believe those areas of activity, so being an attorney, which means engaging with clients, being a professor and lecturer, being an advocate in private practice and in the state, and being a judge and heading up a human rights organization. I'm used to leadership. I am able to act independently. My skill set is such that, I said it earlier, I can hit the ground running. I'm confident in my skills because of my background and history. And my knowledge of the law spans the gamut. I've written on the gamut of the law. And the other thing I think that I bring to the table is that I have an ability, and that's demonstrated in my judgments, I have an ability to, when I'm faced with an area of law that I didn't practice in, like tax law or patent law, I can very easily get on top of that and render judgments that are solid. And I think that is particularly needed in the SCA. You know, in the SCA, you deal with everything, bar competition law and labour law, quite frankly. And so the SCA really requires judges like me who have that breadth of experience which has been put into practice, not simply in an academic sense, but in a real practical sense. And then finally, I think my judgments and my life story show that I have a demonstrated record of understanding the need to progress the Constitution. I understand what it means to be a lawyer and a judge in our constitutional dispensation. And so in some of my judgments, I have developed the law. For example, in YG versus the state, I've developed the common law. So I'm not afraid to do what it takes, to act fearlessly and without fear and favour, and to promote the Constitution and constitutional values.
Thank you very much, Justice Keightley. Thank you, Chief Justice.
Thank you, Minister.
Yeah. Thank you very much, CJ. With your indulgence, I've got two questions. Good morning.
Good morning, Minister.
Yes, my first question relates to your judgment that was confirmed by the Concord in the separate matter of the religious, but is the YG versus the state.
Yes.
Yes. I'm just interested in the reasoning that you had put there, that I'm just looking for the correct wording. But it is to the extent that the court had implored that parents must find a different form of disciplining their children.
Yes.
Because of the removal of the common law justification or defense.
Yes.
What kind of discipline were you envisaging in that judgment? Because there is just confusion in society now. How should parents handle the discipline of their kids?
Certainly the judgment didn't say how parents should. But what it turned on was the common law principle that gave a defense that to a charge of assault, that existed only for parents or other caregivers when chastising their child, punishing their child. And it was on those grounds and within the context of the rights of children that I found that the common law, continued common law recognition of allowing parents to raise the defense that they were meting out what essentially would otherwise be an assault in the name of discipline and punishment was okay in the common law. And that I found was contrary to many of the children's rights that are embedded in our Constitution, as well as to basic rights of dignity, bodily integrity. And it was ultimately upheld, as you know, by the Constitutional Court, not necessarily along the same lines. So it was a straight, I approached the matter from the point of view, was there infringement of rights? Yes, there was. If there was an infringement of the right, was that infringement justifiable under Section 36 of the Constitution? And I found that it wasn't justifiable. And so in that sense, we didn't go so far as to say how parents should. What we were saying is if you choose to, what the effect of the judgment is if parents continue to choose corporal punishment, to enforce discipline on their children, they will be open to being charged with assault, if that should happen, on the same basis as anybody else who has assaulted any other person. So that was the effect of the judgment. It doesn't, I don't think it had the effect of immediately stopping parents from meting out corporal punishment. But they need to know that if they do, they can't come to a court and say, but it was okay because I was disciplining my child, and our law for well over 100 years has recognized that that's okay. So that was the thrust of the judgment. I'm not sure if that answers your question, Minister.
Yeah, no, it does.
Thank you.
My second
Could I just say, I think it does need the limits and the boundaries might need extrapolation in statute. So that may well be something that your ministry is considering.
Yes, it is. That's why I'm asking. But
yes.
Thank you very much. I think it helps. The second one, with the indulgence of the Chief Justice, is in relation to NA and others versus the National Director of Public Prosecution. On how you...
I'm sorry, Minister, I just didn't get that. The acoustics in this room aren't great.
NOP and others versus the
National Director
of Public
I've got
Prosecution.
you.
Yes.
Yes.
The differentiation on the restraint order granted under Chapter 5 of POCA and under Chapter 6.
Yes.
Why did you deem it necessary that it should not be appealable? Because this seems like a very drastic kind of a decision which obviously sees the assets of someone. I just want to get the...
I won't run through the whole judgment with you. I'm sure you can read it for yourself. But essentially, I analyzed the two systems, Chapter 5 and Chapter 6, and where the initial orders, so restraint under Chapter 5 and preservation under Chapter 6, I looked at the purpose of those two different types of infringing on the right to deal with one's property, as one normally would, and what the purposes were that were being served by it within the framework of the Act. But also, very importantly, there are important procedural differences between the Chapter 5 restraint order and the Chapter 6 preservation order. So the restraint order, generally speaking, the parties don't come back to the court, the High Court that granted the restraint order. That order stays in place until the conviction, if there's a conviction, the sentence, and then the the actual forfeiture of the property takes place after conviction and sentence. And procedurally, the civil route of asset forfeiture is very different. So the preservation stage is intended to be short. It's intended to be just a precursor, keeping assets safe, while the civil follow-on process, which happens in the High Court and has nothing to do with conviction. One doesn't even need a conviction until that runs its course in the same High Court. And so there are very important procedural differences, as well as, if one looks at the purpose of each, the role that each one plays in the framework of the Act as a whole. And really it was on that basis that I differentiated between a restraint order, saying it's different in its legal nature and effect, and a preservation order, different in its legal nature and effect. And for that reason, not appealable, because Chapter 6 allows the parties, and in fact makes it plain that parties should hurry up and get into court so that the court can make a final determination on the actual forfeiture of the property. Does that explain sufficiently succinctly to you, Minister?
Yeah, no, it is, because we have been criticized, as you are aware, that such are sometimes very drastic to the people that are affected by such an order.
Yes.
And yeah, because
I understand that, and you know, I was in on the ground when that law was sort of put into practice, and I think the courts have recognized that there is a need for that law if you are going to combat criminality, and particularly organized crime. And so I think it has found its feet. Yes.
Thank you, CJ.
Judge Keightley, I may not have heard you correctly.
Yes.
But did you say something along the lines that the SEA does competition law cases and labor law cases?
No, I said the opposite.
Oh, okay, all right. Okay, no, that's all right.
Chief Justice, okay. I said the opposite.
Okay, no, so I didn't hear correctly.
Yes, you did.
Commissioner Marumwakai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Professor Marumwakai.
I have a question for you that arises from one of the decisions that you wrote.
Yes.
But the question is more academic than anything else. Perhaps maybe it might have a practical effect depending on how you answer it. There's a particular doctrine that you dealt with as MSM on behalf of KBM versus Minister of Executive Council
yes.
for Health.
Is that one of the judgments that I cited?
Yes, it is one of the judgments that you provided. I'll give you the citation now. It is on page 27 of the bundle.
Yes.
Yes.
Is that National Credit Regulator?
No, not that one. The one where you dealt with the defense of.
Oh, MSM and KB. I've got you. Yes. It's my bundle 28, but I've got
it. Yes.
Yes.
No. Actually, you're right. It's 28.
Yes.
In this case, you are dealing with a doctrine.
Yes.
Of public health care defense that we saw has been used by government to ensure that it limits how compensation is ordered when the public facilities yes. can provide. I have my question starts here. Is this a common law doctrine? Because I see a lot of cases referring to this doctrine as a common law doctrine, and a lot of writers refer to this as a common law doctrine.
Yes.
But I cannot see the root of it as to how you can associate it with the common law as a principle? That would be the first part of my,
Yes.
my question. The second part of my question will be whether or not it's a common law thing. It's part of our law, but obviously we know in Mashinini it was disturbed somehow. What is the future of this doctrine when one looks at the current National Health Insurance Act? Is it something that will see more development if NHI is implemented? I mean, there are people who believe that it cannot be implemented, but assuming
Yes.
that it can be
Yeah.
implemented,
Yeah.
what will then be the future of this doctrine? But the first part of the question, I think it's more important because it creates more challenges than.
Yes, thank you, Professor. And you've picked up on something about which there is a lot of confusion among legal commentators and on this very issue. It's well explained in the Constitutional Court decision of DZ, which opened the door. And in fact, one needs to understand that there are two, it's generally referred to as the public healthcare defense. It would probably be better to call it the public healthcare remedy, because it really is a remedy, it's not a defense. What DZ recognizes is that within the bounds of ordinary delictual principles, it is incumbent on a plaintiff to prove their damages, and therefore they must prove the amount of damages. And it is even under common law open to a defendant to say, you have asked for too much by way of damages for future medical expenses, because these services are available to you in state hospitals. You are more likely to use state hospitals, and therefore in fact, your damages for future medical expenses should be limited because it's reasonable damages, should be reduced by 50% or whatever, because most of those services you're going to access and pay nothing for in a public hospital. That's within the bounds of the common law, and I think the SCA case there was Ngubane, which understood that. And that's often confused with the public healthcare remedy. The public healthcare remedy doesn't fall within the common law. And the reason it doesn't is because the common law says that you must prove your damages, you must prove them once and for all, now and in the future. And critically, they are paid in money. And that's where the development of the common law comes in. Because with the public healthcare remedy, what the state asks is that it asks that instead of giving money for services, it will be ordered to provide those services to the plaintiff, and that is then made part of the order. So it's actually a form of compensation. It's a form of damages, not sounding in money. And that's where the development of the common law comes in. So it's all very well explained in DZ. And I think it is important to make that distinction. You have to develop the common law if you are going to recognize that delictual compensation can be in a form other than money by the provision of services, and you oblige the state to provide those services. That's the development of the common law, and that's what I did in MSM.
Thank you very much. Thank you very much, CJ.
Thank you.
Do you still want an answer on your second question?
No, I think you do partly cover it.
I was just going to look in my bag for my crystal ball.
Commissioner Nochesi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner Nochesi.
I have thought that in your debate with the Chief Justice on customary law, you tell him that you actually come from the province of legends. You grew up at Ngeleni.
I did.
I thought you would say that.
Yes,
yes, exactly. I thought you would say that. And now, my question really, Judge Keightley, in fact, I've been following your judgments, well reasoned,
thank you.
well articulated.
Thank you.
Now, tell me, what do you consider collegiality
Yes.
as a key component of a judicial officer? That's only that question.
You're asking if it is a key component? Absolutely. And I think I think on a court that always sits in a panel, the appellate courts always do, whether it's 2 in the High Court, 3, there's collegiality amongst your colleagues. And a court system can't function without that collegiality. You need it. You need to know you're all on the same page, and you need to be directed. And might I just say, I think it extends beyond collegiality with colleagues. Judges need to be seen also to be collegial, and to understand being a judge is a privilege, wherever you are, and you are serving a community. And so, it extends beyond that as well. But I absolutely agree. Collegiality is you will not be a good judge unless you are collegial.
Thank you. Commissioner Makwanishe?
Thank you very much, Chief Justice. Good afternoon, Judge Keightley.
Good afternoon. There you are. Good afternoon, Commissioner.
Thank you. What are the requirements of a class action, and how does it differ from traditional individual lawsuits?
Oh, that's an area that I haven't dealt with. Thank you. I haven't yet had dealt with the class action. So that was a flag for one of the areas I haven't dealt with. Class action is, as I understand a class action, you need the class to be certified and the action to be certified by a court as a preliminary measure, as a preliminary step before the action can be taken forward. I'm making it sound far more simple than it is. It really is very complicated. So you have got to persuade the court that the class of persons who will form the basis of complainants are a class, and that they are, for example, sufficiently bound together with the legal issues that will be determined to be considered to be a class. You have also got to persuade the court that the issues in the case are suitable for determination as a class action. Because you may, for example, have an action against many different defendants. So if I think of some of the class actions involving silicosis, that was against many different mines or mining companies, and occurring over time. And yet you want in one action for those issues to be determined, not on a single litigant, single defendant basis. So you need to persuade the court that there is sufficient cohesiveness also in terms of the action itself, that it should be certified by the class. And there are also all sorts of other requirements that must be met. It is preliminary, and I understand the Supreme Court of Appeal has held it's not appealable, that certification, or not. If certification is granted, that it's not appealable.
Thank you very much, Chief Justice.
Thank you. I have only 2 more, and those will be the last 2, and that's Commissioner Moimang and Commissioner. There will be the objections and complaints side, but I'm now going to Commissioner Moimang.
Thank you, Chief Justice. Good day, Judges Keightley.
Good morning, Commissioner Moimane. Not my Mane. I mustn't. It's election season. I shouldn't get that wrong.
It's Moimang.
Commissioner Moimane.
I'm sorry. Before we proceed, let me mention, with the past 2 candidates, we were doing roughly an hour. We are 1 hour 15 minutes with this one. So I'm just warning everybody. Okay, go ahead.
Duly noted, Chief Justice.
Thank you, Chief Justice. In the judgment of AfriForum,
yes,
versus the chairman of Council of UNISA,
Yes.
The AfriForum took issue with the remarks that Justice made, because in your remark you said, as South Africans who have less melanin than our fellow South Africans, we could learn to move more forward than more back. I'm more interested in terms of your reflection on the fact that AfriForum took issue with that, but located within the values of our constitution, particularly section 1 that talks about those values. Thank you.
I'm constrained not to answer you with my perceptions on the complaint, because there was a formal application for my recusal from a panel dealing with another AfriForum matter, and judgment is yet to be handed down. And so I can't comment, Commissioner. I do hope you understand that.
No, I think that is in order. I wasn't aware of.
Yes, yes.
No, I fully appreciate it. Thank you, Chief Justice.
Okay, thank you. Commissioner Mangena.
Thank you, Chief Justice.
Good morning, Commissioner.
Good afternoon. My question arises out of the judgment where you wrote a minority judgment with, or you concurred in the minority judgment with Judge Catherine Sitilwane.
Yes.
Yeah.
That's to do with the record in Rule 53 matters.
Rule 53 matters.
Yes.
Yes, and that's where my question is.
Yes.
I've always been under the impression that the Supreme Court of Appeal is generally reluctant to adjudicate over on appeal matters on a piecemeal basis. And I couldn't understand why would your court be interested in considering an interlocutory order?
Yes, that's an extremely good question. And we considered that question in the panel, and the short answer to it is that, although I don't think it's teased out very much in the judgment, but the short answer is if you order a party to produce a record, that record in proceedings, that record is then produced. It is there. It can never be recalled. And you may have situations where they produce a record that is then in the hands of, the other litigant, and that record, the documents in that record, will then be open to. They'll be a part of a public record, and so in a sense there was some final effect, because you can't then recall that record back, can you? If it's ordered that a party must produce that record as part of the appeal, it sits there, it's there. It's open for the applicant to use those documents as and when it wishes to in the trial. And so, to that extent, it was also understood to be an important question. And you'll see, and it's an important question because there was a dissenting judgment, and it turned. So for those two reasons, it was felt that the appeal should be heard.
Thank you, Chief Justice.
Thank you. Commissioners, we have got to come to an end with this interview. I'm really not allowing anybody beyond Commissioner Steinberg and Lucas, but if you can, Commissioner Steinberg has indicated it's fine.
I'll withdraw in the interest of time.
Commissioner Lucas, do you insist on your question? I hear you saying no. Silence means no.
My hand that was up instead of...
It's actually Commissioner Singh.
Oh, I was told it was Commissioner Lucas. I'm sorry. Commissioner Singh, do you insist on yours?
A very quick one, Chief Justice, because it
Okay,
deals with criteria.
it's the last one then.
Yes, sir. Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
I'm on virtual. One of the criteria that we have to apply as commissioners is experience when we are
Yes,
appointing some.
yes,
Now, I note that you were only appointed in 2016 as a judge, but you have 39 years of experience in the law field.
yes,
And secondly, I note that in the SCA, you were there from July 23 until April 24,
yes,
which is also a relatively short period compared to others. But then I also note, and this is my final point before asking the question, that you served as presiding judge in appeals as a senior judge of the High Court.
yes.
And the question is, how has that helped you? And do you think that has equipped you sufficiently to assume a position in the SCA? Thank you.
Thank you. The short answer is yes. I think my judgments speak for themselves. In the Supreme Court of Appeal, I've written judgments on some of the issues I've written judgments on are complex issues, and I feel I've acquitted myself well. And then my years of experience have all equipped me to be a very good SCA judge. My years, I have a good legal brain. I know how to analyze law. I have a mix of practice as well as academia. And that has all equipped me incredibly well. That's why I said I have followed a rather unique path. It's not as if I suddenly became a judge in 2016 and now wish to be elevated to the SCA. So I do feel that my entire gamut of experience equips me very well. And then, of course, sitting in a very busy division like ours, I've been sitting on panels of full court appeals and full bench appeals from when I was an acting judge, working my way up to presiding there. So I'm well versed in how one deals with appeals, the nature of an appeal, the powers of the court when the court deals with appeals, the limits of those powers. So I have absolutely no hesitation in giving a complete assurance that my elevation at this stage is timely. I have the experience, I have the capacity, the capability, and I believe I have demonstrated that.
Thank you very much. I am satisfied.
Thank you,
Chief
Commissioner.
Justice.
Thank you. That was the last question. Thank you very much, Judge Keightley. We have come to the end of the interview. Once again, thank you for availing yourself for consideration for appointment to the SCA, and now you are excused.
Thank you very much, Chief Justice and Commissioners and Minister.
Thank you.